Good afternoon, everyone. Welcome to the ITAR Lunch and Learn webinar and workshop. We do have audience joining us remotely as well as you here in person. We're glad you could all be here with us today to talk ITAR hot topics. The program here today is designed to help you understand and assess corporate compliance and reduce liability concerns. We encourage you to ask questions and have a good discussion about ITAR topics. In addition to the questions from our live audience here today, those joining us remotely can ask a question either by typing the question in the webinar dashboard under the Questions tab, or click Raise Hand tab on your dashboard, and as soon as I unmute you, you can ask your question here to our experts here on the line. If you are remote and want to ask a question, you do need to use the pin located on your audio tab. Today we're honored to have two experts here, Chuck Stockwell and Larry Ward, both from Dorsey & Whitney, our wonderful hosts here today. Larry Ward is an international business attorney, helps clients navigate the complex alphabet soup of international security laws and international trade compliance. Larry helps government contractors involved with international trade understand and comply with the various complicated U.S. regulatory schemes. Next joining us is Chuck Stockwell. He's a senior attorney here at Dorsey & Whitney. Chuck advises clients on the many U.S. export controls and embargo matters. Prior to his role at Dorsey & Whitney, Chuck has served as the Director of Defense Trade Control Policies at the State Department, where he was responsible for developing and enacting the President's export control reform programs, including revisions to ITAR. So very knowledgeable on that. A few important reminders here. This is a live microphone, so we will be broadcasting to our remote audience as well as recording the program here today. We will provide, I think you all probably have picked up a copy of the slide deck. We will be providing also a recorded version of today's presentation to you after the event. If those of you that need CLEs for Bar Association certification, Dorsey & Whitney has applied to have this count for CLEs. So there's some sign-in form and some form that you need to fill out if you'd like to have those. Any questions before we get started? Right? I will turn it over to our experts then.
Thanks. So just on behalf of Dorsey & Whitney, I just wanted to welcome you all here today, and thank you for coming to the office for the discussion on sort of hot topics in the ITAR world. Before we get going on the actual presentation, just given the size of the crowd, we thought it might be useful just to sort of quickly go around the room and just introduce yourself, sort of where you're from, and sort of what brings you to a presentation on ITAR hot topics. So I realize that the folks that are online won't have an easy opportunity to do that, but for those of us in the room, I think it might make the discussion a little bit more engaging if we just kind of know who each other is and sort of why we're here. And I guess the one thing I would ask is if you could kind of speak as loudly as possible so that one of the microphones around the table can pick you up, so that the people online can hear you. That'd be great. So you want to go ahead?
Absolutely. I'll start. So my name is Kyle Thompson. I'm with Blade Tech Industries. We make holsters, firearm accessories, carry equipment for military, law enforcement, and civilian use. Really our purpose for being here is we do quite a bit of business overseas, internationally. Those markets are growing steadily. Just really want to make sure that we're in compliance and doing everything we can to make sure we stay that way.
Bryce Wagner from Blade Tech. Unfortunately, this is as loud as I go, so if they can't hear me, so I'm the CEO of Blade Tech, and Kyle said, we're rapidly growing our international exports and want to make sure that we're in compliance, and looking at future product lines we want to release are going to be compliant as well.
My name is Robert Moon from Blue Origin, and we're making spacecraft and launch vehicles, and obviously in the world of the simplification of the reform of ITAR makes for a more complicated environment, which we welcome. You know.
I'm Audrey Powers, also from Blue Origin, and I deal with many of our export controls and regulatory matters as well. Diana Crum with White House Food Lines. We actually manufacture some aerospace products that are under the ITAR requirements. And I'm here more, not around because we do any exporting directly, but because I want to know what the employment requirements are.
John DeGero, I'm the Puget Sound Regional Manager for PNDC. Thanks so much for joining us today. I'm based in Seattle, actually, just you can see just across the waterway there. If you have any questions about PNDC and want to learn a little bit more, please let me know. Thank you.
I'm Ellen Wetzel. I'm a patent attorney here at Dorothy's Seattle office, and I'm just generally interested in the subject. I have a background in aerospace engineering, and to the extent that I work with clients in this area, I think
Oh, I'm Tricia Murphy. I'm actually a reporter with WB Public Radio, and I asked the company about that. Nobody's going to get close. I'm a military veteran affairs reporter, so I'm just here because I don't know a whole lot about it, so I'm curious about it.
I'm Amy Aaron. I'm with Sam in Southern Oregon, and we play with the military and expanding international business. We just wanted to get some more.
I'm Maddie Story. I'm with Microsoft. I'm a lawyer at Microsoft, and I advise my clients on developing cloud computing solutions that are capable of dealing with customers who have ITAR.
And I'm Kate Canapo. I'm on staff with PNDC. I manage the programs and events and managing the webinar today.
Great. Well, great. Welcome everybody. So one great thing that Kate did with the registration process was that she sort of asked everyone if they wanted, as part of the registration, to sort of indicate if there were specific questions that they were hoping to have addressed today, or certain topics that they were hoping we would discuss today. There was an opportunity to put that on the registration form, and I think a lot of people really did take advantage of that. And so Chuck and I intentionally tried to cater our presentation sort of around those general questions. So I think a lot of what you guys came here curious about today will be addressed at some point during the conversation. Of course, if it's not addressed, feel free to ask questions. Both of us are happy to take questions throughout. It certainly makes things a lot more engaging, I think, for the audience if we have questions throughout. So don't be shy to ask your questions throughout. If it's something that we know we're going to talk about on a future slide, we may defer the question until a bit later, but certainly encourage you guys to engage in the conversation. With that said, this is sort of the agenda of what we're hoping to go over today. It's a lot to cover. There's sort of 10 different topics, but some of them are sort of one slide only, and so we think that we'll go through them pretty quickly. A couple of the areas too are simply proposals of sort of where things stand right now, and so they're not current law. They may become law at some point in the future, but they're sort of general interest topics to sort of keep your eye on, but not necessarily anything that you sort of need to know in order for compliance at this point in time. Given sort of the broad audience, we thought it would be useful in the first sort of two topics that we hope to discuss. We thought it'd be useful just to give a general overview of the ITAR. For some of you, you're well versed in the ITAR already, so this will really be review. Others of you, though, that really are just coming in more from a general background standpoint, may find some usefulness in that general background material. And then also we wanted to talk about export control reform and where things stood right now. Again, some of you may be very well versed in where things stand in your particular categories on the USML, so this may be a little bit more of background for the folks that are coming into this a little bit fresher to the topic. Just in terms of the ITAR, the ITAR is administered and enforced by a group within the State Department that's known as the Directorate of Defense Trade Controls. That's obviously where Chuck was before he came here to Dorsey. And the DDTC is sort of responsible for everything with respect to defense trade. So if you need to go to get a license to export something, you go to DDTC. If you don't know whether something is a military or a defense item, you go to DDTC to ask them their opinion. If you happen to violate the ITAR, something goes wrong, the compliance efforts that you took weren't quite up to where they needed to be and something slipped through the cracks, you go to DDTC to report that apparent violation of the ITAR and resolve that with DDTC. So it's sort of a one-stop shop for all defense trade needs. However, DDTC does regularly consult and work with other government agencies. The two that it works with most closely are the Defense Department, which obviously has a very significant interest in defense trade, and then also the Commerce Department, because the Commerce Department is the other department within the government that regulates U.S. exports on the dual use or civilian side of things. So those are the two entities that DDTC will work most closely with on defense topics, but there are certainly other government agencies like the NRC or DOE that, depending on the topic that's coming to DDTC, might get consulted on something. The heart of the ITAR is the USML, the U.S. Munitions List, and that's the list that indicates which items are considered defense articles and defense services. For most everyone in this room, it sounds like you all have some fairly good exposure to the USML and to the ITAR already. And so for most of you, you likely know that in the past, 5-6 years ago, the USML was a very generic list. And so it had entries that basically said, you know, something that's designed for a military purpose. But it didn't really go into sort of any sort of technical parameters, didn't go into any detail to sort of help you figure out what it means that something is defense or military as opposed to commercial or civilian. And so it was really hard for companies, particularly suppliers to large government contractors, to understand whether they had something that is considered USML controlled or not. About 7 years ago now, the Obama administration identified export controls as an area that really needed reformed, because what was happening was that a fighter jet was controlled to the same extent that a screw or a bolt that goes into the wing on the fighter jet that you could go to Lowe's or Home Depot and effectively buy an equivalent. That screw was controlled to the same extent that the fighter jet was, because the screw happened to be specifically modified or designed to go into the fighter jet. And so the Obama administration realized that this was something that was leading to absurd results. It was leading to results where U.S. companies weren't able to compete with primarily European counterparts, because those European counterparts didn't have the same regulations that they needed to comply with to export their items, and so could work a little bit more freely. It also led to the absurd result that U.S. government agencies were getting charged exorbitant amounts for items that could only be sold to the U.S. government, because the regulations effectively cut off the rest of the world supply chain, because European competitors could do everything much more cost effectively. So as a result, through Secretaries Clinton, Locke, and Gates, the Obama administration worked together on this export control reform process. And specifically, one of the things that they did was to give greater specificity to the USML. And so, as Chuck will talk about in the next section, over the course of the last several years, the government has worked to specifically enumerate on the USML those things that are going to be controlled. So it gives U.S. companies a much better sense of whether or not their items are controlled. There's been a public comment period for each category that has been revised so that U.S. companies can weigh in on whether they think the regulations, the changes to the regulations are good enough for their particular industry, or whether there are things that they suggest for the government to consider. So it's really been an iterative process back and forth between the government and industry to sort of revise this USML. So now the USML is moving to the point of the Commerce Control List, which is the control list on the ear side of things, where the USML is becoming much more specific. And so you can actually see technical parameters. You can see specific listings. Any manufacturer, exporter, or broker of defense articles or services has to be registered with DDTC. For some companies, this export control reform process has meant that they formerly were making defense articles or providing defense services, but export control reform has sort of shifted all of their stuff off of the USML, and they're now on the CCL side of things. And so they no longer need to be registered. So when you look at sort of compliance efforts, that's one of the first things that U.S. companies are having to determine now, is whether they need to maintain that registration with DDTC or whether they can let it lapse. And licenses on the ITAR side are required everywhere in the world with some very limited exceptions. This is very different than the ear side of things, where there are a lot of exceptions. So even though it may look like you need a license to export your item out of the country, a lot of times you can rely on license exception, and so you don't need to get a license from the government. The ITAR is in some ways a little bit nicer, because it's sort of, if you know it's USML controlled, you know you have to get a license. And so from a compliance perspective, sometimes it is a little bit easier to work under the ITAR because you know the licensing regime pretty easily. Whereas on the ear, there's a very large ramp-up process to sort of understand those license exceptions. And so for a lot of companies, again, whose items have shifted off the USML over to the ear side of things, it's become difficult for them to really understand when they need a license, when they don't. And it's much more of a checkerboard approach. Everything on the ITAR in terms of processing licenses is done through the D-Trade system. On average, things with DDTC take 30 to 90 days. That's sort of the general time frame. In recent months, we've sort of become aware that commodity jurisdiction requests are taking longer than typical. So in the past, you could get a CJ determination back from DDTC in 30 to 45 days. It's taking more like 60 to 90 at this point. Licenses, same. There are sort of fewer license applications going in nowadays, but as part of the reform process, there've sort of been higher walls built around more items that were sort of considered the crown jewels of the U.S. defense system. And so as a result, those licensing decisions are becoming a little bit more complicated for the government to make in some instances. So the license applications in some instances are taking a little bit longer. This slide just lists out the various parts of the ITAR, and so if you're new to the ITAR and you need to sort of understand, you know, how do I register, you can sort of go to that part of the ITAR. If you need to know what licenses are, you can go to those various sections of the ITAR. The next slides I'm not going to review in any sort of detail, but they simply give you the definition of what a defense article is, what a defense service is, and then this slide is oftentimes the one that becomes the most complicated, figuring out what technical data is. So technical data is actually fits under the definition of defense article, but this is sort of the technology. This is what most of you are sort of dealing with when you're working with foreign partners to develop an item. And so gaining an understanding of what exactly is technical data and then making the determination as to whether technical data is controlled under the USML or not is a critical thing that you have to do in your compliance efforts. This slide lists out examples of things that could potentially be considered technical data. It's not to say that in every instance it's going to be something that is technical data, but these are examples of things that could be technical data. So you can see that it's a very comprehensive list. Effectively, if a qualified engineer or qualified designer could look at one of these things and figure out how to reverse engineer something, it's probably going to be considered tech data. If they could gain or glean important technical or engineering information from something, it would be picked up under tech data. Under the ITAR, there are some general policies just to be aware of. 126.1 sort of lists out those countries that are entirely off limits when it comes to defense trade. Probably the one that is, particularly for suppliers or smaller companies, the one that oftentimes comes as maybe a bit of a shocker, a surprise from sort of where you're hoping your business to go, is China. China is under a policy of denial for the DDTC, so that effectively means that DDTC will not grant any license application for exports to China. And then there's a list of other countries up there which are often less of a concern because you don't tend to have business partners on the commercial side in many of those countries anyway.
Is that for China, is that for all products on the USML or just select products?
It's everything, yeah. And the real, the careful thing to understand too for those of you that have had items shift off of the USML over to the CCL is that 126.1 policy of denial has carried over for those items to the CCL. So if it used to be something that was controlled on the USML and you couldn't export it to China and it's moved over to what's called the 600 series, again, that policy of denial is going to be in place. So although a lot of other things on the EAR can be exported to China, with a license or under a license exception, this 126.1 policy of denial carries over for those 600 series items.
Let me just add, if I can, Larry, there's such a thing as a presidential waiver for 126.1. There was somewhere in the neighborhood of 10 exceptions that have been granted by presidential waiver for exports to China. For example, there were, after they discovered chemical weapons left by the Japanese after the end of World War II, a special exemption was allowed for cleanup in China, and also for Olympic security during the Beijing Olympics. So there are procedures where you can get presidential waivers.
But if you're just looking to enter into a partnership with a business in China to make something cheaper, it's probably not going to happen. It's not going to rise to that level of a presidential waiver. And then these are just some other general policies with respect to the DDTC or the ITAR. They're sort of situational specific. But one of the things that export control reform has tried to do is to sort of free up or make trade with certain key allies a little bit easier. And so over the last several years, the ITAR, there have been amendments to the ITAR to sort of allow for a little bit easier exports to Canada in some instances. And then with respect to Australia and the United Kingdom, a lot has freed up over the last several years. So this export control reform process has impacted some of these general policies as well under the ITAR. And with that, I'm going to turn it over to Chuck to give us an update on sort of where things stand with export control reform.
Okay, as Larry mentioned, we're now several years into export control reform. It really really got started in August of 2009 when President Obama had set up an interagency task force. One may go back even a little further than that and go back to a study by the National Academy of Sciences, which found that our restrictions, our attempts to safeguard technology went so far that it was actually interfering with our ability to compete overseas, as Larry mentioned. And it spurred on things like the ITAR free movement in Europe and elsewhere. So as a result of the Academy of Sciences study in the task force that was set up, there was a goal to move towards what we call the four singles. That meant a single list of items, end items that are controlled, a single agency for the purpose of licensing, a single IT system for licensing, and a single enforcement agency. And the intent was to do this in 3 phases. Right now, we are really fairly well through both phases 1 and 2. Phases 1 and 2 really consisted of a reconciliation between the laws and regulations on the international traffic in arms regulation, the ITAR side, and the export administration regulations, or EAR side. Most of those actions for phases 1 and 2 could be accomplished without congressional buy-in or a requirement for legislation. There was one exception to that. The change to control of spacecraft in associated items, that is Category 15, required congressional authorization to reverse an earlier piece of legislation known as the Strom-Thurmond National Defense Authorization Act of 1999. That was in the wake of a mishap involving the launch of a satellite back in the 90s. Anyway, Congress did accommodate and did allow amendments to Category 15, and that's why we are where we are today. Most of the restructuring of the U.S. munitions list did not require nothing more than simply notifying Congress, and that's because of the Arms Export Control Act. Phase 3 is a little more complicated. In order to set up a single system, a single licensing system, it requires reconciliation of two different legislative mandates, the Arms Export Control Act and the Export Administration Act, the latter of which had lapsed a number of years ago, and Congress has been unable to renew or come up with a new Export Administration Act. That is a lot more problematic. Perhaps there is some light on the horizon, or hope on the horizon. Brian Nielsen in the White House has been kind of directing this process, indicates that, and based on his discussions on Capitol Hill, there appears to be a more cooperative spirit on Capitol Hill. So it remains to be seen if we can move forward to phase 3 and reconcile the two statutory authorities and move forward. So I'm going to talk a little bit about ITAR USML revisions in more detail, and also substantial progress has been made in reconciling the database. This is U.S. Exports database, Commerce Department among the last of the agencies to come on board with U.S. exports. So let's take a look at the USML revision process. Based on the National Academy of Sciences study, the intent was, as Larry alluded to focus on the crown jewels, that is higher fences around fewer items. We focus on the most critical technology. That means we can move the lesser technologies over to the EAR, or the Commerce Control List. That meant that minor end items and components, such as nuts and bolts, can be moved to the Commerce Control List. But it also meant a new methodology. It meant that on the U.S. munitions list, we are going to try to create a positive list, as opposed to the old USML, which relied more on catch-all categories that used words like including the following items, or but not limited to, and in language like that. The intent was to move away from these catch-all types of categories and positively identify through enumerated lists types of items that we would be controlling. At the same time, part of the compromise with Capitol Hill meant that we had to provide a higher level of protection for those items moved over, because in some instances we're moving over to Commerce Control List control or jurisdiction items that are modified for military purposes. And I'm going to talk a little bit later about the new specially designed criteria. But part of the compromise meant that the specially designed components and parts not otherwise enumerated are going to be moved to a new 600 series. By the way, there's a special 500 series set up for spacecraft and related articles, very similar in some respects, a little more controlled than the 600 series. Also, on the Commerce Control List, they control technology as opposed to technical data. That required a little reconciliation between what's controlled on the ITAR side and Commerce Control List. And I'm going to talk a little bit about that as well later. It meant we needed to look at de minimis rules. Generally speaking, the Commerce Control List had no did not have a see-through rule if you had any USML content in products sold overseas. For the 600 series items, there's no de minimis for embargoed countries. So special rules, they created the 600 series with a special focus on D5 countries in the Commerce Control List, as well as 126.1 are embargoed to countries on the ITAR list. So no exceptions available for the embargoed countries. This slide is just a graphic way of focusing on two of the major export control departments. As Larry mentioned, there are other departments involved in export controls, Department of Energy, Treasury is involved in sanctions, but most of the things that we're talking about here today are controlled by these two departments. So the whole export control reform movement or effort was geared at moving items that are not the crown jewels, or not items that we require that higher level of security, and moving them to the Commerce Control List. And even some cases, they're going to be specially designed items, as I mentioned, items specially designed for military purposes. And the result has been quite significant. If you look at where we are right now, there are 21 categories in the U.S. munitions list. 15 have already been revised. Final rules have been passed and adopted. There are 3 proposed rules pending, which I'll talk about in a little more detail later. And there are 3 categories yet to be revised. The categories yet to be revised happen to be categories 1, 2, and 3, firearms, artillery, and ammunition. By the way, a little information that Brian Nielsen had passed on back in our conference in July. 3 years ago, they had actually drafted amendments to or revisions to those first 3 categories. Unfortunately, that happened to coincide with shootings in Colorado, in Connecticut, which made it politically a very bad time to try to push those things through. So that unfortunately meant that those revisions were pushed back. We might expect to see them at some point in the future. They're already drafted and ready to go. And anyway, this next slide shows 2 or 3 of the pending categories, which I'm going to talk about in more detail. That is Category 12 for sensors and night vision devices, Category 14 toxicological agents, and Category 18 are directed energy weapons. One thing, before we leave the slide, I will point out is we're at a place now where we're approaching 2 years since implementation of some of the revisions. Particularly aircraft and gas turbine engines. We are in October. We will reach the 2-year point. The significance of that is the transition rules are going to expire. That means that if you have an existing TAA after October, you can no longer use that existing TAA for USML controlled items. That forces you to use the CCL for those items that have transitioned over to the other list. And by the way, even in January, we're approaching the 2-year mark for submersible vessels and vessels of war. So changes are moving rapidly ahead. I'm not going to spend a whole lot of time on metrics, but and there are a lot of different metrics going around. Some metrics even have 80% reduction in certain categories, of up to 80% of former USML licenses moving over to the Commerce Control List. The statistics vary depending on what the criteria and date and time period that you look at. Most important theme and takeaway from this is, regardless of how you look at it, the changes are significant. Export control reform has resulted significantly in moving items off the ITAR and USML list over. And also very significantly, DDTC, where I used to work, has been downsizing. It's going to downsize from 7 divisions to 4 divisions. So very real effects, both in terms of licensing and organizations in Washington, D.C. Let me just mention very quickly in passing that there's only one method of determining jurisdiction. The official jurisdiction is rendered by DDTC, and that is a commodity jurisdiction process. A commodity classification request, or sometimes known as a CCAT, Commerce Department calls it, is not a determination of jurisdiction. CCAS is simply a determination of where an item is located or controlled on the Commerce Control List. And oftentimes when a commodity jurisdiction determination is rendered, because it's an interagency process, there will be provided an indication of what the proper ECCN classification will be.
Just to interject one thing there, oftentimes, so there is no legal requirement that you get a CJ or that you file a commodity classification request for a CCAS. You can self-classify any item. A key thing, though, to just point out is that if you classify it incorrectly and you indicate that it's something that's controlled on the CCL, and in reality the government views it as USML controlled, your self-classification holds no weight when it comes to violating the ITAR. Certainly could be used as a mitigating factor in a voluntary self-disclosure, but if you self-classify incorrectly, you self-classify incorrectly, and the government's not real concerned with that. So as Chuck mentioned, the definitive way to determine whether something is USML controlled is to file a CJ request.
Yeah. And by the way, one of the reforms made to the CJ process was to publish results. That was one of the things we had done when I was there, and that's now published at the DDTC website. So you can have the benefit of seeing previous CJ determinations when it comes to assist you in determining the jurisdiction of your item. Very important to the export control reform process is this idea of specially designed. This was a new terminology. By the way, it had previously been used on the Commerce Control List for years. It was also the terminology that was used in international arms control regimes like the Boston Arrangement and Missile Technology Control Regime. But what this means is it captures the idea of things designed to meet special performance levels that are uniquely military. Part of the reform was to set up a catch and release process. You might have an item that may be captured because it is a product that's modified to meet certain performance levels, but then if you follow subsection B, if it meets any of the 5 criteria there, it would be released from control. And in those 5 items below are if a CJ determination is found it to be controlled by the Commerce Control List or not otherwise controlled by the USML. If it is a minor part, such as a nut, bolt, fastener, washer, spacer, insulator, we've specifically ruled out those types of lesser parts that do not require an ITAR level of control. Or if it has the same function or performance capabilities equivalent of an item that is not controlled on the ITAR, or it was developed for use with both commodities on the USML and not on the USML. The idea is if it's something that's not uniquely military, the common theme throughout these 5 sub-criteria, if it's not something uniquely military, if it's something shared with a civil or commercial function, generally speaking, it does not meet the specially designed criteria. Okay, moving on to more specific changes to the USML. Category 12 probably is the most contentious, I believe, in my experience, both from my perspective in Washington, D.C. and then outside of government. And the reason why it was one of the most contentious is the very properties of items like night vision devices and focal plane arrays, fire controls, lasers. They have tremendous commercial application, but they also have very significant, in many cases, very significant military applications. There's a great challenge for military, Department of Defense, and Department of Commerce to hash out which items belonged on which list. Anyway, the proposed rule came out in May of this year. So they looked at items, fire control, sights, aiming devices, lasers, looking specifically at, again, military functions when it came to lasers, not just lasers generally, but target designators and range finders. Perhaps the most controversial subset of all these are infrared focal plane arrays or night vision devices. And again, very, very contentious because of both the significant commercial and military uses. There's a comment period that went out. There were a lot of criticisms that came in that too many dual-use items are still controlled. Items widely available on the commercial market. Very interestingly enough, there was a significant carve-out that was provided for focal plane arrays. If they are placed in tamper-resistant, incorporated into camera cores, for example, there's a huge exemption that basically covers most bare IRFPAs or those incorporated into higher order assemblies. If they meet those parameters of tamper-proof, will be exempted from control. This is still one of these categories where design intent is still going to be important. And unfortunately, there is some overlap with other categories such as space category 15. Biggest takeaway that I can give you on this is that there looks like there's going to be a second round of comments based on recent inputs we had from DDTC. So there's take advantage of that opportunity. So we'll have a second. So this is not the final word on the rules. There will be a second comment period. If we look at category 14, before I proceed and spend a lot of time on it, anybody here in the working or associated with chemical or biological or pharmaceuticals? If not, I'm not going to spend a whole lot of time on this. This is mainly focused on toxicological agents and chemical agents. Suffice it to say, again, true to the theme of export control reform, attempt to move to more of a positive list. Significant changes, removing riot control agents, moving it over to the commerce control list side, an attempt to set up a risk-based tiering, and special controls on equipment with specific military applications in mind, weaponized agents and weaponized uses. I'm not going to spend a lot of time on that if nobody else is involved in that industry. Category 18, directed energy weapons. This is a big area for optical industry or those involved in lasers. The new rule came out in the 17th of June, and there was a comment period, which has come and gone. The biggest change, again, similar to some of the other categories, was to remove the old catch-all language, which words like including but not limited to a list, and move it to a more specific definition, which includes any kind of equipment or end items whose primary purpose is to degrade, destroy a target, disturb, disable, damage electronic circuitry, sensors, explosive devices, deny area access, cause lethal effects, or cause permanent or flash blindness. If you look at the comments, there are a lot of concerns that this definition is broad enough to collaterally capture certain industries that may not really be intended for military purpose. For example, there are laser products to remotely cut, weld, or drill items. So some of the comments so far have been focusing on unintended consequences of capturing some of those types of devices. Anyway, one thing I will point out about as we move towards export control reform, it really does not, as we move towards enumerated lists, it doesn't mean that there are going to be fewer words. If anything, it means that the ITAR is going to be longer regulations as it attempts to try to capture those specific items specifically designed for military purposes. So anyway, this is one of the exceptions in this category where they provided really more of a catch-all list of describing functions as opposed to specific functions or specific enumerated lists. With that, I'm going to turn it back over to Larry.
So I know that at least one person in the room is at a company where there's interest and concern around hiring foreign nationals, and my guess is there's probably others around the room that didn't specifically identify that as a concern, but where the concern obviously exists. The concept of deemed export is effectively that if you have technology or if you have software here in the United States, it's real easy to think about exporting a hard good overseas and identifying that as an export. But if you have software technology here in the United States and you share that with an individual, that sharing could be considered an export if you're sharing it with somebody that is not considered a U.S. person for purposes of these regulations. And so under these, or at least under the ITAR and the ITAR, a U.S. person is considered a U.S. citizen, lawful permanent resident, or a green card holder, as they're often referred to, or somebody that's here on asylee status. It's pretty rare that somebody that's here on asylee status is probably going to be working at a company that has ITAR or ITAR concerns. But nonetheless, that's who's considered a U.S. person. If it's somebody that is merely in the process of getting a green card from another country, they're still considered a foreign person for purposes of the ITAR and the ITAR. And so the concern is that if you are at a company where you have ITAR-controlled tech data, or you have ITAR technology that would be controlled to a particular country, you have to consider that sharing with the foreign national as an export. And so the ITAR, this session is supposed to be focused on the ITAR, but there's obviously going to be some natural overlaps with the ITAR. And I use the ITAR example here because it is the regulatory scheme that most clearly identifies what a deemed export is, and it gives some very specific examples. So demonstrating a product to a foreign national could be considered a deemed export. Allowing visual inspection can be considered a deemed export. Orally exchanging information, or foreign national access to source code, specs, drawings, etc. I think one thing that often gets overlooked within companies is email. So it's obviously real easy to share an email with 10, 12 different people that are just on the listserv or the to list in a particular chain. And it could be that you attach a document to that email chain that's considered ITAR controlled, and you didn't realize that one of your engineers from Germany happens to be on that exchange, and that the company doesn't have a TAA in place to allow that sharing with that individual. So all of a sudden you've exported something to that individual without a license, and so that's considered a violation. So the key is, if you have foreign national employees, you need to identify first whether or not they're going to need access to ITAR or ITAR-controlled technical data or technology, and if they are, then you need to ensure that you get a license in place to allow that sharing to take place. If you identify an individual that's a foreign national that does not need access to that technology or tech data, and you do not want to apply for a license to the government, because although the government doesn't charge fees for it, it can be costly in terms of preparing the application, takes time, and can take internal costs to do that. You have to ensure, though, that you have other ways to build protective walls around that foreign national employee so that you don't have inadvertent sharing. And so this is something that you really have to get down to a granular level. You really have to think about all of the examples that are listed up here, but you have to get down to that thought process of emails that are going to be going back and forth. You have to think about your lunchroom. And if you have a group of engineers working for your company and they'd ordinarily gather around the lunch table and talk about a project, you have to think about, if you have this foreign national that you don't want to apply for a license for, but he or she is going to be engaged in those lunchtime conversations, is somebody going to slip and accidentally talk about an ITAR project or a project that would require a license to that foreign national? And you really have to educate your employees so that they understand what can be shared and what can't be shared. The difficulty for companies is sort of the employment laws. And you obviously don't want to have any sort of discrimination. You don't want, the EEOC has obviously laws about discriminating against potential foreign employees. And so it really is sort of a tightrope in some ways that you have to walk in order to ensure that you're allowing that foreign national employee the ability to work for your company in compliance with the EEOC, but also that you're complying with these export control laws. This has really become a concern in the last several years because there was a change to one of the immigration forms, the I-129, that effectively requires you to check off a box as to whether or not a license is required. And so that's sort of how it's come up as a concern for companies that sort of had never thought about it in the past. The other area to really consider, and this is probably one that is more widely applicable than just the foreign national employee, is foreign person visits. So I would imagine that every company in this room has foreign partners that they're working with currently or that they're considering. If those foreign persons are visiting your company, you could engage in a deemed export to those individuals. So it's really important to think about the visitor process. If they're going to actually have access to something that's controlled, you have to get a license from the government in order to allow that sharing. So you really need to think about this process. Your foreign visitors can very easily be offended if the topic that you're supposed to discuss is suddenly off limits because you didn't pre-plan and you didn't get a license in place. So this could kill deals if you don't think the process through long in advance. Sometimes your sales folks may not give you enough advance warning, so you sort of have to appropriately handle that. But on average, the minimum time that it's going to take for a license is 4 to 6 weeks. So just be very mindful of that in your process when you're scheduling foreign person visits.
Yeah. I know BIS has come out with guidance on potential or non-potential deemed exports to foreign nationals when they're in an IT support role. Has there been any reconciliation with ITAR in the same area?
So that's stuff that is sort of ongoing, and we're going to look at in one of the future slides. The DDTC has relied on what's known as DTAG, the Defense Trade Advisory Group, when it comes to cyber concerns. And as of this date, it's sort of one of those topics that is sort of ever evolving. And we'll sort of look at sort of what guidance has come out to date in one of the future slides here. But it is something that the government is, I think it's probably fair to say that it's an area where the government does not have the technical expertise to really understand what the concerns are. And so they're really relying on industry to sort of help them identify what the concerns are. And so I'm actually a member of DTAG, and the group that I'm working with right now is focused on cyber items. And so the government just doesn't even have its arms around sort of what things could actually hold defense tech data. And so it's really sort of helping the government identify where the concerns lie, where they don't lie, when the obligation should be on the provider of perhaps the cloud services solution or the cyber solution, and when the obligation should be on the entity that's providing something to that provider to put into the cloud. So those are all sort of things that are ever evolving, I think, within the government, but no definitive answers really yet. These slides sort of just talk about in more detail some of the things that I already mentioned about concerns that you have to think about when you have foreign national employees and foreign visitors. The one area that I'll just kind of point out on this slide is, anybody in the audience do classified work? Okay. The NISPOM treats the definition of U.S. person differently. So under the NISPOM, which regulates classified work in the United States, a U.S. person is only considered somebody that's a U.S. citizen. So if you're a green card holder, you're not wrapped into that definition. And there's also some regulations around the NISPOM that sort of allow you to discriminate in the hiring process as well, or not necessarily discriminate, but you can put out an ad that foreign persons may not apply for this particular position. But it doesn't sound like there's any classified work at any of your companies. There has been a recent proposed rule under the ITAR to sort of pick up registration and licensing of U.S. persons employed by foreign persons abroad. It's a rule that proposed rule that came out back in May, and there are things that DDTC considered and things that DDTC didn't consider, or at least it doesn't look like they considered when they came out with this proposed rule. So there are a series of comments from some major defense contractors. I think this might be one of those areas where either DDTC realizes and understands the comments that have come in from Airbus, BAE, Raytheon, and others, and revises the rule to pick those up, or it's going to be an area where they come out with another proposed rule before they implement the final rule. So I think that this one's sort of one that's going to be evolving.
Okay, one of the fairly recent changes to the ITAR requirements involves unmanned aerial vehicles, which came out in August, just last month. And the requirement here is a new requirement that, in addition to the DSP 83, non-transfer and use certificate, there's a special addendum which requires signature by the end user if it's a permanent sale, by the way, which requires that the end user certify that the UAV will not be used in violation of international humanitarian law and human rights. There's a litany of requirements in this new addendum that went out with the. This is, by the way, is not a proposed rule. This was an actual notice of a new requirement under the ITAR. I suspect that DRL, the Human Rights Section of State Department, and possibly Capitol Hill had something to do with this new requirement, which came out, and the increasing use of UAVs overseas.
I think UAVs is another area too where it's sort of evolving like cyber. I think there's things the government understands and doesn't necessarily understand, and so it'll be sort of one of those that continues to evolve. I don't know how many of your companies export on behalf of the U.S. government or for the U.S. government or make exports to the U.S. government overseas, but there is a license exception under the ITAR that allows you to rely on this exception. You don't have to go and get a license from the government to make certain exports to the U.S. government. You need to be really careful about this, though. There are some very technically specific things you have to do in order to rely on this license exception. And just because you're exporting something to the U.S. government overseas doesn't necessarily mean that this exception applies. So you really have to drill down into 126.4 to understand whether or not you can use it, and to make sure that you're satisfying all of the paper or record-keeping requirements that are required under this exception. Okay, among the changes recently were very significant changes were revised definitions for key terms. And for example, one of the first items was defense services. This has been an item of contention over the last several years. As early as 2011 and also previously in 2013, there have been various proposals to revise the definition of defense services. The first two proposals did not proceed beyond that the initial comment period. They finally come back now when this new rule was published in June, and they've revised the previous iterations of it, removed language like use of other than public domain information, because that was casting the net too widely to capture a lot of things in terms of defense services that would not have been captured. So that's the biggest change from the previous definitions of defense services. But significantly, they've proposed changing the definition of technical data, and there are a lot more words in this definition. It's less a matter of changing the scope of technical data, but this is an attempt to reconcile the ITAR with the AAR, and so what they've done here is technical data required for the development, production, operation, installation, maintenance, repair, overhaul, or refurbishing of a defense article, which is not exactly the same, but it's a lot closer to the AAR definition. In particular, they've taken care to define terms of production
and development to make it similar to the AAR definition. So again, not really a change in scope, but an attempt to make the definitions more consistent with the AAR definition. They also provided definition of required, which they use language similar to specially designed, that is required meaning peculiarly responsible for achieving or exceeding controlled performance levels required for military end items. Very significantly, there's also a change to the definition, or proposed change to the definition of public domain. What they've done here is an attempt to simplify and add greater versatility. They've made clear it does not include, when they say domain, they mean items generally available to the public. They've made clear that simply having copyright restrictions is not one of those restrictions that prevents it from being considered public domain. If it's something that's considered company proprietary, that's a different matter when it comes to public domain. But they made clear that copyright restrictions would not be used to remove something from being considered as public domain.
Sure.
They've also, sure.
If something's on the internet, does that now qualify as public domain? If it's freely available on the World Wide Web?
Yes and no, and that was and right, yeah, and part of that actually goes to the second part of it, the revision to the definition of public domain, and it's talking about unrestricted. You know, if something is restricted by either a company or an owner from being disseminated to publicly, that rules it out of public domain. But also the government. It is, to answer your question, you could conceivably have a case where somebody decides that they don't like something being, we want to make it public domain, and releases it on the internet. You could have a case where it still remains technical data. What you have there is a violation. You know, simply by turning it over to and publishing it on the internet does not suddenly make it public domain. That means it's a violation. And if you look very carefully at the second part of the definition of public domain, it talks about prior approval, authorization for release required by the Department of Defense. What the new definition does specify, though, is that it puts an onus on government to restrict it in the first place. If it was never restricted, if your university or your research institute or your company has a contract with the government and there are no restrictions placed on publication of the results of that research, then it's not restricted by this definition in the first place. If the government or the sponsor has put restrictions on it in the first place, then that's a little different question, even if it's released later inadvertently in violation of a proprietary or non-disclosure agreement or in violation of a contract with the government. So that's the answer to the yes or no part of public domain. But the new definition does move us a little further in throwing the onus on government, and rightfully so. If the government wants to sponsor research through universities or the private sector, it forces the government to specify that from the outset that this is what we're going to control in terms of the research. There's also significantly, they've taken the definition of fundamental research, which was included as a subset of the definition of public domain, replaced it with the new section 120.49 that talks about technical data arising from or resulting from fundamental research. And again, it talks about if it was understood, it's intended, there are no restrictions, or it's intended to be published widely, then it's going to qualify as public domain. Also very significantly, mass data storage, and I'm going to talk, we have a couple slides a little bit later, as Larry alluded to. We'll talk in a little more detail about mass storage data in cloud computing. But very significantly, with the revision or proposed revision to mass data storage, which is in section 120.52A4 of the ITAR, it talks about, it removes from the definition based on recommendation of the DTAG, removes from the definition of technical data, encrypted data. So basically providing a way out for cloud service providers if data is is encrypted from end to end, as Commerce Department describes it. Encrypted from the inception, and access is denied to unauthorized parties. That's not considered technical data. So the new proposed definition rolls that into the ITAR. We'll come back a little bit later and we'll talk more detail about what that means in terms of cloud computing.
Yeah, so just in terms of compliance measures, compliance concerns, I think that's sort of a general topic that a lot of folks are interested in. I think a lot of it we've sort of been talking about throughout the session today. One of the biggest concerns with export control reform is to really understand the applicable set of export control regulations. And for some companies, that may mean that they're learning an entirely new set of regulations. For a company that formerly had everything controlled under the USML and now everything's shifted over to the CCL. For other companies, it may mean that they're sort of now having to learn and understand two different sets of regulations. But really understanding the regulatory schemes that you're working under. One thing that often gets missed or overlooked is whether you're checking your foreign partners against the various denied parties or prohibited persons lists that the U.S. government has. There are ways that you can do that manually. One of them is to go to the export.gov website, and that has a consolidated database. There are also software programs available that can seamlessly incorporate into other systems that you may have in place already that sort of run those checks for you. It's really important to run those checks on your foreign partners. As we've sort of talked about throughout today, the CJ process, filing for commodity classification requests if your items do fall on the ITAR side, knowing when you have to actually apply for a license or when you can rely on a license exception, monitoring foreign persons and deemed exports, and then ensuring that you actually keep records or documentary evidence of your compliance with the export control laws is really important. Documents or records can all be kept electronically, so there's no need to keep everything in paper copy. The requirement under both sets of regulations is simply that you can reproduce the records if the government asks for them. So if you have them all stored electronically, as long as you can print them off or provide them in emails to the government, that's sufficient. If your company doesn't have an export control compliance program, it's important to build one. And in order to build one, there's sort of some very key things that need to be considered. First is it management commitment, and the fact that all of you are in this room today means that somebody within your company's management is committed to export control compliance. So it's probably pretty easy to sort of wrap this in. But sort of the biggest thing is your risk assessment, figuring out where the concerns are from an export control standpoint for your company, and then how you actually protect the company for the various risks that you have. Anybody can go to the web and type in export control policy, and there's going to be hundreds of them that pop up, but they're all very specific, or not necessarily specific, but they should be specific to your company. So you can get lots of export control policies out there that you could simply replace the name of whatever company you pull it from with your company's name and call that your export control policy. But they could be somebody that is entirely within the tech space, and you could be somebody that's in a manufacturing space, and so the concerns may not be the same. So it's really important that you tailor your compliance policy. I think the last point down under the written compliance program is really something that's important. So it's sort of real easy to put a paper policy in place and then sort of just leave it there on the shelf. What's critical from the government standpoint is that you're constantly assessing how your policy or how your compliance program is working. So monitoring those that are in charge of export controls, and then regularly auditing the system. And so that could mean a planned audit. So you go to your export compliance manager and you say, we're going to have an audit of you next month, get all your documents in order, and we'll sit down and see what could be improved. It's also real important, though, to do spot checks. so unannounced, visits to folks that are impacted in their day-to-day role by exports to figure out whether they understand what they're supposed to be doing and whether they're doing it appropriately. And that will help you sort of fix problems before they become violations. This we sort of talked about throughout, just knowing the commodity jurisdiction and transition plans. If you've flipped over to the EAR, there's nobody in here doing classified work, so I'll skip over this slide on NISPOM requirements and then turn it over to Chuck for our last quick section on cyber.
Yeah, so as I mentioned earlier, the proposed change is to remove encrypted data from technical data. This relates back to a DTAG white paper that was came out in several years ago. But DTAG, which for those of you not familiar with it, it's a group that consists of people from the private sector and industry. It's a means of industry input, in private sector input into changing the regulations. And the DTAG group said to deal with the problem of cloud computing, we need to either change the definition of technical data or definition of exports. The DTC decided to go along with the proposal to change the definition of technical data. So that change to 120.52 redefines technical data. At the same time, there are efforts going on the Commerce Department of Commerce side. There is a BIS ruling that the cloud service provider is not an exporter, therefore not a deemed export. Very significantly, the BIS proposed a rule, which just came out in June of this year, talks about a requirement that there should be end-to-end encryption that is uninterrupted from transmission onward. Must be inaccessible to third parties. Must be unclassified data only. There's a whole different requirement if it's classified data, according to the NISPOM. Cannot be stored, very significantly, cannot be stored in servers in ITAR 126.1, that's in embargoed or sanctioned countries, or EAR D5, the D5 list of countries. There's a little bit of disagreement between the Commerce side and the State Department side, between DDTC and BIS, as far as what is the standard of encryption. DDTC decided to go along with FIPS 140-2 level of encryption, which basically describes minimal levels of security for protection. BIS was a little more flexible. It basically said that you can use the FIPS 140-2 level or functional equivalent. So I suspect there will be a little more reconciliation and discussion between the two departments over time to reconcile those different variations in standards. So some practical advice pending the official revisions to the ITAR and EAR. Providers should look for certification from providers that no servers are provided in the D5 countries or Russia. It's encouraged to use only FIPS 140-2 NIST certified level of protection.
I don't think NIST actually certifies something compliant. They just provide this to
Right. Yeah. I'm sorry. When I say NIST certification, it's NIST is certified in the
certified to be compliant with the NIST standard.
Yeah.
Right. Exactly. Yeah. Also, very important to monitor employees and contractor temporary storage of export-controlled data, and very importantly, watch out for OFAC embargoed countries and make sure that access is denied, and pay attention to Treasury's specially designated nationals, or SDN list. And the very important takeaway to leave you with is that these proposed rules are not official yet. There's several more months. I expect to see some reconciliation, further discussions between State Department and Department of Commerce and other affected agencies. And with that,
so that's the end of our prepared comments, and sort of sections 3 through 9 were really we sort of tried to tailor to some of the specific things that came in over the registrations to PNDC. So hopefully we addressed some of the thoughts or concerns that folks had. But at this point, we just sort of wanted to open it up for discussion, for questions. Certainly, if folks need to leave, certainly able to come and go as you want at this point. But if you do want the CLE credit, just make sure you sign a sheet before you go. But we just wanted to open it up to any questions or just discussion that you all wanted to have. And certainly, if anybody online has anything, certainly happy to answer those questions as well.
So I have a question. You mentioned the see-through rule, Chuck.
Mm-hmm.
Can you talk through the status of that? You probably want to give a preamble of what it is and
Sure.
Where it stands after reform.
Right. See-through rule, for years, that had been one of the distinguishing features of the ITAR and probably one of the most hated parts of the ITAR. And the see-through rule meant that if you had a part or a component embedded into even an item controlled by the EAR, let's say a commercial, in the old days, commercial satellite, maybe you had a part for whatever reason was controlled by the ITAR. It's embedded into an EAR device. See-through rule meant you would look through that otherwise EAR controlled item and that whole product would become ITAR controlled. So it became one of the most hated parts of the ITAR because that meant that even if your product was otherwise appeared to be civilian and commercial, it meant that now it was controlled by the ITAR, which meant you had third-party transfer rules and all the other requirements go along with the ITAR. So among the changes, particularly you see this in category 12, where they certain items in commercial satellites, or I'm sorry, not commercial satellites, but focal plane array and night vision devices, if they are embedded and meet the criteria of the revised or proposed category 12, and they're tamper resistant, meaning that they cannot be removed without actually destroying that item, so that they can't be stolen by whatever nefarious entities are out there. So that tamper resistant means a level of protection. So that's a way around the see-through rule. At the same time, you notice that there's a bit of incorporation of the see-through rule moving over to parts of the 600 series when you're, when it comes to embargoed countries. That was part of the compromise, particularly in your area in category 15 in space, that there's still concern on Capitol Hill about things going to China. And so anyway, so embargoed countries, you'll find that part of the see-through rule has moved over in part anyway to the Commerce Control List. Anything to add to that, Larry?
No.
Another question, if I can.
Sure.
I noticed the spacecraft interim final rule. So it's been an interim status for over a year. Do you know what the path is or what the plan is for it to be a final rule, or will it likely stay in interim status for several years?
The main part of the main amendment is actually in effect for category 15. So I'm not sure which one. There have been several different rules. There was a special rule that had come out, I know, June of the previous year for like radiation tolerant and radiation hardened components, electronic components. So I'm not sure which part you're referring to that's still in interim status. The major part of category 15 I'm familiar with has already gone into effect. So maybe.
My recollection was it was on interim status, and the slide reported it as an interim final rule.
Then that's probably a mistake on the slide, because it, in fact, I think it was October the previous year that Cap 15 is in effect.
Okay, thank you.
Other questions?
Closing thoughts?
Now, has anybody online had anything?
I haven't had anybody. If anybody online would like to ask a question, please just type it in the question category on your control panel or raise your hand and we'll unmute you.
If there aren't any other questions, we want to thank everybody for coming today, and certainly if there are any other questions that you may want more privately asked, Chuck and I are happy to stick around for a little bit afterwards to address those as well. But otherwise, thank you all for coming.
Thank you. We appreciate your hospitality and expertise today. A reminder to everyone, we do have some upcoming PNDC events. We'll have a War for Talent webinar coming up October 15th. I know that is something on everybody's mind. We'll also have a networking luncheon at Esterline Control and Communications in Everett on October 29th. And we will actually be conducting a day-and-a-half ITAR summit. So a lot more in-depth and includes some case studies in Portland on December 9th and 10th. And then do not forget about the PNDC annual dinner, November 11th in Portland. So that concludes our webinar today. Thank you so much, everybody, for joining us.